Again.
Sorry.
Page 335. Is there a reference in that note as well to Maya's pain complaints escalating since the mother was at bedside?
Yes, it says Maya's complaints of pain have escalated as well since her mother is at bedside. Mom requests oxycodone specifically. Discuss with Mom that it's better to ignore Maya's moaning and only give her analgesics if she asks. We also want to encourage her to take ibuprofen and only resort to the oxycodone for severe pain.
You mentioned earlier that you're fairly conservative with pain medication. If this patient were, well, you mentioned also that you had had a number of patients referred to you with CRPS.
I have, yes. In my experience with CRPS, it's always involved a limb, a single arm or a single leg, or, hand or foot or something like that. So there's usually weakness, there's pain, there's often sleep disruption. So there's often an element of a mood disorder, whether it be anxiety because of pain or some degree of depression symptoms, or a combination of the two. So pain control and using medication to help improve pain control, I think, is very important. And sometimes I also prescribe medication to help with sleep and pain. And there are some medications that can serve both purposes. And with the pain better controlled and the focus of my treatment approach involves rehabilitation interventions, like physical therapy to perform stimulation to the extremity, weight bearing, range of motion, strengthening, using modalities like heat or ice or contrast baths, using electrical stimulation like a TENS unit or something different type of electrical stimulation. So there's a role for medication, but for me, I think the medications play a limited role, and it's really the other interventions with the use of the extremity and the weight bearing that tend to really help those symptoms resolve. But without the medications, sometimes the patient can't tolerate the therapy.
Page 120. So in your experience, is the treatment of CRPS in the pediatric setting a multidisciplinary activity?
Absolutely. And one thing I didn't include in my common recommendations is getting psychology involved, and it's not necessarily, it may be to help address symptoms of anxiety or depression, but it's also to teach the patient and the family methods to try to control pain without medication, non-pharmacologic managements of pain.
Going back to your notes for a moment, looking at your note of August 10th, there seems on page 310 let me just point it to you. Under the physiatry portion of the plan, the first sentence of that.
It says, quote, reports of Mom being resistant to medication reduction. Dad states that he had discussions with Mom and she's agreeable for now. Limit medical conversations in the room. Steroid wean completed. Further wean off Valium today. We'll discuss the necessity of repeat serum cortisol levels with Dr. Kornberg and continue plan of care. This centers on positive reinforcement, structure, and boundaries. Maya continues to make steady progress with this plan of care.
Page 124. Doctor, we've gone back and forth a lot today, but with everything you saw through this, would you agree that Mom and Dad Kowalski cared about their daughter and were doing everything possible to help her?
I think that requires me to take a step beyond what I'm able to say I know. I can say that I never got the impression in my interactions with the family that they were doing anything to the contrary of that. But I don't think I've had enough exposure to them or know them well enough to say that they were doing everything possible, to help them. Again, but I didn't see anything that would suggest that that was not the case.
So, Doctor, what can we say is you didn't see any indication that these parents were either one of them were trying to abuse this child, did you?
I didn't see any. I didn't see any evidence of that in my interactions with them, no.
That would conclude the deposition, now.
Okay, members of the jury, this is a good place for us to stop for today.
Gentlemen, we approach just very briefly.
We do it after we let the jury go. Yes. So, members of the jury, do not discuss this case amongst yourselves. Do not do any investigation and receive no information, and we'll see you tomorrow. We see that. Okay. Okay, the jury's out of our presence if you all want to come up now.
Oh, it's not. I can say it with the guy listening. It was just, I was just looking for a similar instruction of Bonnie Rice about the dates of the TGH admission, just like we did yesterday, so they'd have some, they'd be oriented. And I think Ms. Crawls had the same plan, but that's okay.
Maybe we can publish records.
We can do that first thing tomorrow. Question, are we going to want to do, I know we got the Detective Graham issue. Are we going to do more exhibits tonight? Do you want us to come in, knowing that we're going to go until 6 tomorrow, do you also want to come in at 8:15 tomorrow, or do you want to work tonight?
Judge, well, I would only say that I think the medical records council was going to look at tonight to see if there were, as to which ones were not already in, and we wanted to look at that one medical record. I think tomorrow's better, is what I'm saying.
Okay, so tomorrow at 8:15, and then we'll get here at 8:15, we'll do records, and after the jury leaves for the day, we'll keep doing records
All right, so
and exhibits.
Okay, I'm hearing your honor.
We're trimming the sails.
What's the Detective Graham issue?
Did you need to take a break, your honor, before we do the?
Well, I'm trying to figure out how long this is going to be.
I'm going to guess, I don't know, I'm going to guess it's a 10 to 15 minute argument, but that's just a swag.
What do we have?
They're objecting to Detective Graham.
Oh, so why don't we do the Detective Graham now? I'm just going to stand, because I've been sitting way too long. So.
Your Honor, I think they told us just before lunch that they intend to call Detective Graham tomorrow. We previously filed a motion in limine to exclude her interview altogether for various reasons. At DIN 2531, the court entered an order limiting the use of Detective Graham's interview for really any purpose except for impeachment, which the defense attempted to use with Jack Kowalski. And then the order further stated that if they wanted to offer Detective Graham for any other purpose, they had to specifically seek permission outside the presence of the jury. I can continue in my argument against it, or we can give them an opportunity to.
Well, I mean, my order is at DIN 2531. So, I mean, I remember reviewing and listening to Detective Graham, and I think the issue is what they're going to seek to elicit from him. And I mean, I guess these are statements by Jack Kowalski, so we've got an exception to the hearsay, but otherwise it's a hearsay conversation.
Yes, Your Honor. I plan on calling Detective Graham, just briefly walking her through her education and training, and then establishing that she sat down for a conversation with Mr. Kowalski. And during that conversation, I intend to elicit about 6 to 8 statements that he made as admissions by party opponents. I have the audio that I'd also like to play in conjunction with. I'm happy to preview all of those with Your Honor, so you can, before we do it in front of the jury, so that way we
What are the statements that we're talking about?
if I can pull up my outline, I can tell you specifically if you'd like to know that. Almost there, Your Honor.
In Ms. Crowell's, was there a percent, because it looks like we used about 55 minutes for that. Was there a percentage that you can give me?
I can count the pages and we can divide it up. I think it's usually a minute a page kind of thing.
Well, I mean, is it like 2/3, 1/3, 75%, 25%? Just give me the rough approximation.
Yeah, I'll give you a rough draft. Just give me 1 second. It's highlighted different colors, so I can give you a quick.
Thank you. Mr. Shapiro.
Yeah, I apologize. I don't have the exact transcript with me, but there was a statement about that Mr. Kowalski made where he told Detective Graham he did not think it was in Maya's best interest that Mrs. Kowalski was calling the hospital. the statement that he observed Maya's pain levels to be different depending on who was in the room, the statement about Mrs. Kowalski making inappropriate comments on the phone during supervised calls.
Wait a second, say that one more time.
Yeah, there was a statement that Mrs. Kowalski was talking about inappropriate subjects with Maya during the supervised calls, including talking about the medical care and the lawyers. This might be a little bit easier to do with the transcript, but that's the subject. And then a statement about that if Maya came home, he would have his wife move out. So there's about a half dozen
If
statements
Maya came home, what?
that he would have his wife move out.
We don't believe that those statements are relevant to any pending claim in this lawsuit. The police interview, the detective's interview in the hospital was not part of our negligent infliction claim, which Jack no longer has. It's not part of our intentional infliction claim. It's not part of our medical malpractice claim, our battery claim, or our false imprisonment claim. So it doesn't go to any pending issue in this lawsuit. It's part and parcel of the Chapter 39 proceeding. So we object on all those bases. And 403. Additionally, I don't believe Jack Kowalski representing what Beata Kowalski may or may not have done qualifies as a party admission. And I'll point out additionally that we did have at one time malicious prosecution claim, abusive process claim, and Chapter 39 false reporting, all of which were dismissed on summary judgment. So with those no longer in the case, we don't see how this is relevant.
Your Honor, I know you're looking. Some of this might be easier if I can give you the page lines, because none of this is a mystery. You can actually see what the audio is going to sound like.
Well, the audio is not in evidence, right?
No, and I don't plan on putting the whole audio in evidence, but I can do it either way. I think it is a statement by a party opponent, and I did plan on playing the audio in conjunction with their answer. I'm obviously not going to move the audio in evidence, but I believe I can publish I do believe I can publish the audio and move it into evidence in that regard, yes.
Well, you're not publishing anything unless it's in evidence.
Right, I apologize for the statement. Yes, I do believe we can move the audio into evidence as a statement by a party opponent. Clips of the audio. I do not plan on putting in the 2-hour-plus interview. I was going to select, like I said, somewhere between 5 to 7 clips in total. There was one other one in addition where, and it's very important to our case, where Mr. Kowalski had told Detective Graham that he was in favor of staying at All Children's Hospital after that team meeting that was described, I believe, by Nurse Klink and Dr. Teppa on October 11th, where he says, I was in support of staying. So that would be the other one that I would tend to elicit. I don't know if Your Honor wants to go through each one with page and line. I can have someone try to pull it up, or what your preferences are to do it in the morning.
Anything else, Mr. Whitney?
It's the stigma of having a police officer come in, so that adds to the veneer.
Additionally, I did appear here on the stand to buttress this argument that Mr. Kowalski was doing something improper.
And we have not explored yet the
surreptitiously recorded.
Well, here's where I'm at. The statements are statements against interest. They go to issues that remain in the case, and they are relevant. So certainly you're going to be able to call the detective and elicit those statements. We can talk about the clips in the morning, but the plaintiffs will be able to cross-examine as to whether this was done covertly, not covertly, that she was wearing guns and all of that stuff on cross-examination. But yes, you will be able to elicit those statements. Anything else?
We may ask for a proffer because it's going to get very dangerously close to Chapter 39 dependency proceeding territory, and the dependency proceedings are full of party admissions by the hospital, which we haven't been allowed to explore. We think this is part of the Chapter 39 process.
Well, I am confident there's going to be very specific question and answer, page and line, or pieces of the clips that we'll be able to have in isolation, and then we can call it. But generally speaking, what Mr. Shapiro was describing will be allowed as statements against interest, and so it's an exception to the hearsay.
Yeah, that's a good question. Does the defense know if Detective Graham or Patrolman Graham will appear in uniform? If so, we'd object.
Oh, no, I don't think she is. She's retired since March of this year. I don't know if she still has uniform. I told her to come dressed professional. Well, I think she's coming in blouse or something of that nature.
Okay. Anything else?
We
had additionally the curative instruction I tried to bring up earlier regarding the.
Have it written out.
I'm sorry.
Have it written out, and we can.
It's in our motion. I'm sorry. We'll bring it in tomorrow.
Have it written out.
We'll do.
Judge, I'm going to suggest that it was 80% defense and 20%. Are you guys good with that, with Dr. Kohlberg?
80-20, fine.
Yep.
Are you planning on playing Nebby Walford tomorrow?
Walford? No, I don't believe so.
Okay.
So for that 15 minutes and 40 minutes.
Yes.
Okay.
Is that 80-20?
I'm going to try to get out of here a little earlier tomorrow.
We'll do 10 and 45. How
Thank
about
you.
that?
Appreciate that.
We'll shave that 5 minutes there for you, Mr. Whitney.
We might need it.
That's
Mike?
just.
I was trying to pull the hook on Mr. Anderson several times, so we appreciate the 5 minutes.
It was because I did not cross on the second witness.
So that means the timing today, plaintiffs used an hour, 40 minutes. That puts you at 48 hours, 15 minutes. Defense used 3 hours, 15 minutes, which places you at 22 hours, 22 hours, 5 minutes. Okay, and what was the next thing, Mr. Anderson?
I was going to try to get out of here early. It's my daughter's 12th birthday, and I haven't seen them in a very long time. So I was just trying to figure out what was going to happen in the afternoon. And was there any chance that Officer Graham can make it earlier? Or are we doomed to after lunch?
I don't know the answer to that. I was playing Dr. Kornberg, and as soon as I leave court, I will call a decision.
As she's
I've got a
retired.
meeting at lunch, so we've got to take lunch tomorrow. But I'm serious, 8:15 tomorrow, and then we're going to go until 6 o'clock. And then we're going to start assessing as to whether we're going to be coming in early, whether we're going to do nights, weekends, but we've got to pick it up.
Your Honor.
And I know you all need time to prepare, but we made a commitment to this jury as to the last day, and we need to keep that.
One additional issue, if I may. The court pointed out that yesterday we displayed Exhibit 2571-005 and 2571-004. 005 at the time was not in evidence. I discussed this with defense counsel. It's really just a close-up of 004, but we'd like to move 005 into evidence to clean that up.
Was there any objection to that?
No objection.
So after the 45-second lineup, it's no objection. So what number are we admitting in?
257005.
Okay, so admitted.
Yeah,
Make it
shot
so.
of her feet in the wheelchair.
Anything else? Right there.
I'm sorry. No.
Okay, 8:15 tomorrow morning. See you there.